Next up, folks, we are going to the Pretoria High Court. For those of you following along in our notes, you can find it on page 2 of your summary and page 73 of your bundle. This is AM versus J.S.M, and that is case number 63415-2023, and the citation ZAGPPHC 133 if you are looking for it on Safley. This is under the pen of Mazibuko AJ. It is a 7-page judgment, a light read, but a very interesting judgment nonetheless, and specifically when it comes to the issue of forfeiture of patrimonial benefits under Section 9(1) of the Divorce Act. Plaintiff sought forfeiture regarding a marriage in community of property, and then also instituted a claim against defendant's pension fund. So plaintiff essentially said defendant must forfeit the patrimonial benefits of the marriage insofar as I am concerned, but I want a claim to 50% of their pension fund. The judgment explores undue benefit. Specifically, as you'll all know, under Section 9(1), the court looks at 3 factors and then determines whether there is undue benefit. The test, obviously, for forfeiture being undue benefit having regard to duration of the marriage, misconduct, and then the circumstances which gave rise to the breakdown of the marriage. Then also the court considers the effect of an extramarital affair as misconduct for the purposes of Section 9(1). We've had an interesting slew of judgments dealing with this aspect over the last couple of years, and it is interesting to see what the court per Mazibuko AJ has to say on the issue, and then it also looks at the duration of the marriage. Notable quotes here in this case where the forfeiture claim was dismissed by the court is in paragraph 15, I think, is the kind of nub of the judgment, where the court stated that the court views the defendant's misconduct relied upon by the plaintiff as not substantial misconduct for purposes of forfeiture of patrimonial benefits. However, a conduct that led to the breakdown of the marriage relationship. So the court distinguished the misconduct as not substantial for a forfeiture claim, but certainly conduct which led to the breakdown of the marriage. Plaintiff testified that the defendant left the matrimonial home on the day the plaintiff found him and another woman in the matrimonial home. She only issued the divorce summons in June 2023, 14 years later. I'm not satisfied that if the forfeiture order is not made, the defendant will be unduly benefited in relation to the plaintiff. In fact, the opposite is correct. Now, an interesting aside which I want to point out to you folks, I just found this quite interesting when I read it, and perhaps you will too, where the court says, I've considered the duration of the marriage, the circumstances that led to the breakdown of the marriage, the defendant's misconduct of having an extramarital affair, and the contribution of the parties towards the joint estate. This issue of contribution has arisen quite a lot in recent years, where the court has really taken that into account in terms of forfeiture, as I think it should, essentially. Also, the spousal maintenance in the amount of 8,000 Rand paid by the defendant, as well as the 50% of the defendant's pension funds claim made by the plaintiff, correctly so in my view. And this is a departure, obviously, from our locus classicus judgments, which really held that the court is limited to misconduct, duration, and circumstances which gave rise to the breakdown of the marriage. In this instance, the court took into account the spousal maintenance paid by the defendant. Very, very interesting, as it seems to signal a little bit of a departure from the very stringent adherence to the 3 factors contained in Section 9(1) of the Divorce Act. Also very interesting that the plaintiff obviously took so long to issue divorce summons. So that was AM versus J.S.M. Pretoria High Court under the pen of Mazibuko AJ, and that is on summary page 2 and then bundle page 73. We've got a question: can forfeiture only happen within community of property? Certainly not. In terms of the patrimonial benefits of the marriage, these can be highly varied, and there have been interesting judgments. A very old judgment, I know there was something that was considered a patrimonial benefit. Forgive me, I don't have the citation of that old judgment. Was a benefits under a lease agreement, but very specifically, we see forfeiture happening when we deal with either marriages in community of property or accrual claims. And then in terms of out-and-out marriages, if there is some form of joint ownership, it becomes quite contentious, because you can only pray for forfeiture in respect of those assets that you hold in your estate. In those instances, the other party would hold 50%, and that would then more fall into the realms of actio communi dividundo. But certainly we see a lot of forfeiture within community of property marriages and out with accrual. Thank you for the excellent question.